Ancient history, but Lopez Torres, a judge in New York State and in Brooklyn, interacted with Clarence Norman, now dead, Vito Lopez, now dead, and it's not pretty. This went to the Supreme Court, and the Supreme Court said, U.S. Supreme Court, and the Supreme Court said that party bosses are allowed to be party bosses. In fact, the U.S. Constitution protects party bosses. But Justice Stevens went out of his way to call New York State stupid and New York City stupid. And as a result of that, we, the complacent New York City and New York State residents and citizens, are stupid by association. Now here it is, Lopez Torres versus poor Elliot Spitzer, but it was really the Board of Elections. And just if you go to this court case and you look for the word daughter, that is sickening. It's just sickening. Right? If you just look for the word daughter, and here it is. Just listen to this. Just listen. I'm going to start it here.
The two party leaders who prevailed upon Lopez Torres were Norman, who was the committee's chair and thus the county party's leader, and Assemblymember Vito Lopez, who was a district leader and a member of the county's executive committee. Through Vito Lopez's avid sponsorship, Lopez Torres had secured the county party's support for her successful civil court candidacy. Norman and Lopez expressed their directive through a letter authored by the secretary of the Kings County Democratic Committee. That letter set forth that Clarence and Vito wished the secretary to refer this wonderful gentleman to you as your law secretary, and that Lopez Torres should obtain the necessary paperwork for his employment. The resume of the favored appointee was attached. Lopez Torres interviewed the prospect and contacted his prior employer, a Brooklyn Supreme Court justice for whom the prospect had served as law secretary. The justice told Lopez Torres that the law secretary's work was mediocre, and that he had spent an enormous amount of time on the phone doing political work. Lopez Torres hired someone else instead. And, extremely upset, Norman later called Lopez Torres and chastised her for refusing the hire. Norman told her that she did not understand the way it works. Attorneys such as the one he recommended, he explained, work hard for the Democratic Party's political clubs to get candidates elected, and the law secretary job is a way to reward them. He demanded that she fire the person whom she had hired on the merits, and hire a person of the party leadership's choosing. Lopez Torres refused. Someday, Norman warned her, she would want to become a Supreme Court justice and the party leaders would not forget this. He told her that, without the county's support, her Supreme Court nomination will not happen. 6. Assemblymember Vito Lopez also confronted her. He told her that her refusal to effect the hire was an embarrassment to him, because he supported her campaign. He demanded that Lopez Torres make it right by hiring the person referred by county, but she again refused. Through an intermediary, he later offered her a chance to redeem herself. If she hired his daughter as her law secretary, he would secure her nomination as the Democratic Party's candidate for Supreme Court justice. She declined the proposition. As Norman had anticipated, Lopez Torres eventually did aspire to the state Supreme Court bench. She contacted Norman, who requested that they meet at one of Brooklyn's busiest political salt licks, Junior's restaurant. When Lopez Torres informed Norman that she desired the party's nomination for a vacant Supreme Court justice position in the 2nd Judicial District, he predictably declined to support her because her refusal to hire his favored candidate for law secretary was a serious breach of protocol. Nonetheless, she entered her name for consideration at the upcoming judicial convention. In an urgent phone call, Norman demanded that she withdraw. Her continued candidacy, he claimed, was a political affront to him, and running in an open convention was not the way it works. She again rebuffed him. At the convention, not a single delegate proposed her nomination. Undeterred, Lopez Torres sought her party's nomination the following year. The Judicial Screening Committee, a body subject to the control of the county party that ostensibly examines the qualifications of judicial candidates and makes recommendations to the party, interviewed her. However, when she requested the committee's report from Norman and its chairman, Jerome Carp. Neither would disclose it. She considered running her own slate of judicial delegates, but realized that such an effort was impossible, as a practical matter. There is simply no way I could ever overcome the organizational and financial burdens to place delegate candidates on the ballot, she concluded. Without any realistic hope of running her own delegates or receiving Norman's blessing, she withdrew from consideration. 4 years later, Lopez Torres yet again sought her party's nomination. Carp informed her that the screening committee would interview only those candidates that Norman referred. Norman, in turn, refused to make the reference. Over the next few months, Lopez Torres pressed Norman for a referral to the committee, but he repeatedly told her that he opposed her candidacy because she had been disloyal. Since she was unable to run her own contingent of delegates and the screening committee would not even evaluate her, Lopez Torres' candidacy effectively ended. That same year, Lopez Torres ran for re-election to the civil court bench. The Kings County Democratic Committee, by now overtly hostile to one of its own elected officials, ran a candidate against her in the primary election. Facing the party-backed candidate in an open primary, Lopez Torres prevailed. In the general election, she received over 200,000 votes, more than any of the Democratic candidates for Supreme Court justice received in Brooklyn that year. In 2003, the persistent Lopez Torres again sought her party's nomination for Supreme Court justice. This time, Norman agreed to forward her name to the screening committee. Regardless, in a meeting with Lopez Torres on June 6, he declined to support her because of her past defiance. He also stated that she lacked sufficient support. Lopez Torres pointed out that the prior year she defeated the county party's civil court candidate in the primary election and garnered more than 200,000 votes to win the general election. Norman responded that county would support only those candidates who supported county, in turn. Lopez Torres nonetheless attempted to lobby convention delegates. Beginning in March, she wrote repeatedly to the Kings County Democratic Committee requesting the date, time, and place of the convention, the names of the delegates, and whether she could address the delegates at the convention. In September, the committee's executive director, Jeffrey C. Feldman, finally responded. He sneered that a learned jurist, such as yourself, be well aware that stand for independent election in the primary election, yet to be held. No list therefore existed, anywhere in the world. As to the prospect of addressing the delegates, Feldman wrote, while I am neither an attorney nor a graduate of law school, I suffer from the innocent belief that the floor of the convention is open, only, to elected delegates and their successors. I am not aware of any convention in my 30 years of attendance, which permitted a non-accredited member to be accorded the privilege of the floor. He closed his letter by chastising her for the alleged improper use of a fax machine, in violation of Federal Communication Commission regulations. At the convention, 2 delegates unsuccessfully attempted to nominate Lopez Torres. After that effort failed, the delegates nominated the slate of candidates that Norman had endorsed. Subsequently, a Brooklyn district leader, who also served as a judicial delegate, penned a letter to the county's other district leaders. He wrote that although Lopez Torres was highly qualified, he voted against her nomination because she was an ingrate who had offended party leadership. Her sin, he explained, was that she courted Vito Lopez to support her for civil court, but then decided she didn't need him anymore and denied his daughter a job. Years of careful study by a number of groups whose reports were in evidence established that Lopez Torres' experience was no anomalous political mugging.
Exactly. You can read this for yourself, but tears come to a person's eyes listening to how horrid this whole system is. Peace out.